rise in temperature anyway.
Tell me if it's too.
Sorry?
Tell me if it's too.
Mr. Saini.
Lord, to move things on quickly, could I take you to my written case?
Yes, you can.
Internal page numbering, page 42, paragraph 99. And I'm on the issue of legal certainty. And I was just about to show the court a few of the Strasbourg cases. But in order to put it into context, it's important to underline what EU law requires when there are interferences with fundamental rights. And here we've got two rights. One is the right liberty, protected under EU law, and the second is the right to free movement, protected under EU law. And the digital rights case, which we cite at paragraph 99, contains a wide-ranging description of the requirements of legal certainty. And not only that, but also emphasises the point that any interference with any of the rights has to be strictly necessary. So any interference with liberty or with free movement rights has to be strictly necessary. A very clear and strict proportionality test. And jumping ahead in our case, I was on paragraph 103, which was the recent Strasbourg jurisprudence.
Yep.
And I've shown you Mathloom in Greece, and in the time I just want to show you one further case, just to make good the point that the absence of time limits in the case of immigration detention is considered unlawful through the lens of Article 5.1. And if you could please go to Authorities Bundle Volume 13, which is the case of Abdul Khani and Turkey, which is MS page number 4504. And within that judgment, it starts at paragraph 128, which is an MS page number 4541. This is a case where an individual had been in...
Just give us the reference again.
I'm so sorry. It's Authorities Bundle Volume 13,
Oh, right, sorry.
tab 150. So at tab 150, within that, on the MS page numbering, it's MS page number 4541, paragraph 128. Internal numbering, page 37 in the top right-hand corner. This is a case of immigration detention. And there's one particular point I want to identify at paragraph 134, but I'm going to come back to an earlier part of the judgment. So 133 and 134, if the court could just please read those.
Yep.
And it's in particular 134, the fourth line. Second line, the government have failed to submit any argument or document indicating the applicant's detention has had a strictly defined statutory basis in law. And then bottom of the page 135, in sum, in the absence of clear legal provisions establishing the procedure for ordering and extending detention with a view to deportation and setting time limits for such detention. Now, before leaving this case, it speaks with the same voice as the Mathloom case and indeed all of the cases that we refer to at paragraph 103. Just before leaving this case, can I draw the court's attention to one point, which the court may have picked up from its pre-reading, which is if one goes to paragraphs 128 and 129, particularly 129 at MS page 4541, internal page 37, 129, the court there observes, Article 5.1f does not require the detention to be reasonably considered necessary. And that's referring back to A and the Chahal line of cases. The court will know, and I don't have time to go to it now, that when it comes to EU law, see paragraphs 68 to 72 of our case, we do not accept that under EU law, anyone can have their free movement or liberty rights restricted unless it's necessary according to a proportionality test.
Help me on this. This line of cases wasn't referred to below.
No.
So we are, and as I understand it from the respondent's case, there has been some consideration of these cases, at least in the High Court.
Well, I think Mr. Ward has some of those cases. I can actually mention 2 points in response to my Lord's point. First of all, the time limits point generally was an issue before Mr. Justice Eder, who expressed disquiet about the lack of time limits, and before the Court of Appeal. They said Hardy or Singh is the answer to that concern.
You're saying it's not. But no, I'm just troubled that we're dealing with what seems to be a pretty important point without any assistance from the courts below, simply because the point wasn't cited. And you're not referring to the cases where apparently it has been considered.
Well, I'm only aware of one case, which I believe that Mr. Ward is citing, where this particular issue has been considered.
And no, I mean, there have been lots of cases in which Hardy or Singh has been considered, including this House. You're saying that none of them, did anyone notice these ECHR authorities?
I'm not aware of anyone having raised these authorities in a other than Mathloom, in a domestic court. But what is happening, and again, I don't have a huge amount of time to do this, but you'll see from our supplementary authorities bundle, and I'll very quickly take to it. It is quite an important point because the Strasbourg court will speak on this issue very soon. This whole issue of whether immigration, detention, particularly detention under the 1971 Act, is unlawful because of the lack of time limits. And we consider it right to draw your attention to, in our supplementary authorities bundle, you will see at divider 182 and 183. These are pure UK cases which have commenced in Strasbourg. And as the court may be familiar, what the court does, and it's much more common now, is of its own motion, it's now got a procedure where it starts to ask questions which it thinks are material to the issues in the case. And it's divider 182 and 183.
Yes.
182 is a case, again, it's a pure UK case concerning the legality of detention under the 1971 Act. And no doubt bearing in mind this developing jurisprudence it has about time limits. If one can please go to the... within this, it's the 4th page. It's the questions to the parties, which are on the very last but one page, page 7.
Yes.
You'll see question 3. Did the domestic legal regime of administrative detention apply to the applicant satisfy the requirements inherent in Article 5.1 as to the quality of the national authorising such detention? In particular, did the lack of any time limits on administrative detention violate the requirements of lawful under Article 5.1? And exactly the same question has arisen in another case, Draga, which is pending before the Strasbourg court. That's at the end, next tab 183, very last page. See the same question. So it is a live issue, and there is...
Yes, I mean, that's why I'm
Absolutely.
concerned about it. It's the live issue
Yeah.
we're being faced with for the first time at this level.
I'm not aware...
And you say for some reason no one has raised it ever before.
Okay. I'm not aware of it being the subject of any first instance or court of appeal.
Why not? I mean,
Well,
you've been in lots of these cases, surely. And
well, this case has taken a rather different turn, and it may also be that we have felt heartened in arguing this point because we have the EU dimension, because we have an added requirement potentially of legal certainty, because we've got an interference with EU law rights.
You're saying that, well, at one point you say they all march together. You just told us, in fact, EU rights are stricter.
Because of the point I made before the short adjournment, because we have a different right as well here, which is the right of free movement.
How are you going to sort all this out?
Well,
I mean, or do we just wait for Strasbourg to tell us what?
no, well, the point is this court should not be waiting.
I understand that.
Absolutely, but can I just... Sorry, can I just...
troubled as what you say we're supposed to do with all this material.
Well, what the court can do in a case which is concerned with EU law rights, which are the rights of free movement and liberty, you can say that it's not good enough to be able to detain someone without a limit as to time.
Your submission, if I've correctly understood this, there must be a nominal time limit, even if there may be extension to it. By way of example, allowing 6 months with a 12-month renewal would satisfy the requirement of certainty. Whether it satisfies the requirement of proportionality is another matter.
Indeed.
But it is fatal to certainty that there isn't a figure regardless of how many times and for what period it may be renewed.
Absolutely.
Yeah.
But it's an aspect of foreseeability, which is that one needs to be able to foresee in advance, not by way of a habeas corpus application, which generally is only effective after one's been detained for a while. One needs to be able to foresee in advance what the maximum duration of lawful detention is going to be. Can I just explain?
I think this is actually quite fundamental. If the whole idea about certainty is that the affected citizen may have a reasonable way of knowing what is in practice likely to happen to them if they do this, that, or the other, how in practice is the individual any more able to make a confident prediction how long he'll be detained if the regulations say 6 months renewable for periods up to 6 months or renewable for 12 months than if you've got ordinary Hardy-Singh principles. In other words, if he's asking himself, well, how long am I liable to be detained for? How's he able to give a better prediction if you've got those nominate figures?
Well, because what we don't have at the moment, unlike the return directive, is first of all a hard period of time, and secondly specific grounds for extending that. And if the Hardy-Singh principles, as they'd been developed, gave a sufficient degree of foreseeability, one couldn't complain. But I just want to show you, my lord, that in fact the way the Hardy-Singh principles are working in practice, there is no hard time limit at all. And I don't accept that one could extend forever. There must be a finite period of time.
Nor is Hardy-Singh.
Well,
The courts, the clear, or used to be a clear authority, which said, look, if a time has come when the circumstances in country X really are too uncertain, then you've got to put a stop to it.
but what's missing here is any hard time limit. And by
I know that, but my question was, how does it make his ability to predict what is going to happen to him any different?
Because he knows that after a certain period of time, I simply cannot be detained for any longer period.
Without a renewal?
Well, there may not be a possibility of a renewal. So even under the returns directive, one can't perpetually keep renewing.
You've got a 12-month renewal under that one. But anyway, but your point about certainty is, as long as there's a figure, there is certainty. Whether it's an unreasonably long period goes to proportionality, not to certainty. And I'm just not sure that I follow why putting a term down with a potential for an extension gives you in reality any greater certainty.
Well, it does, because I know as a matter of certainty that beyond a certain period of time, 6 months or 12 months in the case of the return directive, I have to be released. But at the moment, there is no such certainty. And you will bear in mind, my lords and my lady, that one of the essential requirements of foreseeability is that even if there is not sufficient specificity in a law, in a statute, if one can look to legal advisors and say, well, what is the position? That can often be the deficiency. But we know that the Hardy-Singh principles are not providing that at the moment. And if I could ask you please to go in Authorities Volume 6 to the Firdouse case. And it's not just the comments of the Lord Chief Justice I want to rely upon. I want to rely upon what the Home Secretary herself is saying about the difficulties of the lack of certainty.
Where's this?
It's volume 6.
Yeah, page.
Divider 74, page MS 2614.
Yep. Yep.
Now, this is a case where the Secretary of State had been found by Mr. Andrew Edis, sitting as a deputy, to have detained in breach of the Hardy-Singh principles, and he awarded damages, and the Secretary of State appealed. But my copy of this.
Sorry.
And if you could please go to page 2621, paragraphs 35 to 36.
Yep.
And you see the complaints of the Secretary of State, it's 35 and 36, the submissions.
Yes.
Look at 36. It was said by the Secretary of State the judge had failed to make an objective assessment of the facts as they appeared to those acting with the Secretary of State at the time, but had applied his own subjective views with the benefit of hindsight. This was inconsistent with the rule of law, as the Secretary of State had to be able to determine the lawfulness of detention on the facts as they appeared at the time. And then one sees at 39 to 40 the Lord Chief Justice saying that one can't identify tariffs. It's unhelpful to identify tariffs. But this was in circumstances where the Secretary of State was essentially saying, we don't really know. The law does not give us guidance as to what is a reasonable period of detention. Please give us some guidance by tariffs or yardsticks. So this has been a common complaint of those representing those who are detained. But this is the Secretary of State herself saying, we don't know what the right period is. And I would also underline what's said by Lord Justice Underhill, no doubt through experience of sitting as an administrative court judge dealing regularly with Hardyall Singh complaints. He has sympathy with the Secretary of State because the Secretary of State wants guidance. So we have a position where Hardyall Singh principles are good as far as they go, but they're not providing, and certainly not providing in EU cases, the relevant level of legal certainty.
So how is this supposed to work? The Secretary of State or her official says, well, now, the first thing is I have to satisfy the test that it may be necessary to deport the person. Now, the first question is, how long is it going to take her to decide that question? Because
Yes.
obviously a critical question in deciding how long she's going to take her a week to do that. Let's assume that there is a serious risk of him absconding, and she establishes that.
Yes.
Or that's clear to her. If it's going to take her a week, that's one thing. If it's going to take her 3 weeks, that's something different. But one might perhaps expect her to set out how long that's going to be in the particular case. And the next question is, how long is it going to be necessary for the person to remain in detention until he or she can in fact be deported, having regard to the fact that he or she is being deported to some particular country where the circumstances may be entirely different, where it may be entirely unclear how long it's going to be before it'll be safe, as you put earlier, in a safety case, that for the person to be deported. Now, presumably the decision maker must be having regard to all those circumstances, generating a perfect world, spelling them out and indicating how he or she's arrived at the appropriate period. But you are still left, even if you do all that, you're still left with how long is that going to be at the end of the day? And in the kind of case where we really don't know whether it's ever going to be safe to send them to Timbuktu or wherever, what do? You have a sort of long stop, do you? Arbitrary long stop.
It's not arbitrary in the sense that
it would be arbitrary.
Any time limit is going to be arbitrary in a sense, but there is no reason in principle why the measure taken by the EU for dealing with people who have no rights at all within the EU cannot be adopted in substance here.
It possibly could be, but that's arbitrary too.
Well,
you'd be happy with that, though, would you?
We need a time limit. That's a simple submission. There has to be a time limit.
Could be 5 years.
Well, again, it would have to be justified. It's not for us to prescribe what the time limit would be, but there has to be a time
limit. It would depend
limit.
upon the facts of the particular case, wouldn't it?
Subject to a long stop, always.
But that too, the ascertainment of the long stop itself is fact dependent, isn't it?
Well, in a sense.
Generates in a perfect.
Well, my lord, one doesn't have to look very far to see positions where there's an analogy. So, in other areas of detention, mental health, pre-charging detention in criminal law, there are very clear time limits, and if one wants to extend them, one needs to go to a judge or an independent impartial tribunal. So it's not as if, in the world of immigration detention, there is a completely different problem being
But there's a very big difference there, because in terms of pre-charging detention, the UK authorities are in control of the relevant factors. I appreciate they may not know quite how long it's going to take them to gather evidence, but nevertheless, they've got their own criminal justice system that they are applying. The real problem here is that you're talking about deporting people to Mali, Syria, whatever,
Yes.
areas where the situation is fluctuating. And I don't think you can therefore simply read across from one situation to the other.
Well, I take that point of difference, but with respect, it's not an answer to the point that there should be some point in time after which you cannot detain.
Now, would that mean that there couldn't then be a re-detention in the event of change of circumstances?
It would all again depend on the circumstances.
Supposing you
Yes.
take, none of us know what's going to happen in Mali in the next
No.
few months. Supposing that you had a 3-month period is absolute maximum. At the end of that 3-month period, Mali is still very unsettled, so there's a release. Then in 3 months later, things settle down. The person will be able to be presumably re-detained then.
Well, it would be for the Secretary of State to put forward legislation that provides for that type of situation.
Well, why would you need further legislation to provide for that?
Because at the moment, and this is not my position, it's the position of the Secretary of State in the Court of Appeal, nobody knows how long one can detain using Hardy-Singh principles. It's a guess, and it all depends upon what is essentially an ex post facto judgment of a judge, often after a person has been unlawfully detained for a certain period of time.
Yeah.
And we would avoid that problem and comply with EU law as regards liberty and free movement if there was a certain time limit. Well, I've only got 5 minutes left, and I'm going to come back now.
Just one last point.
Certainly.
And Lord Dyson's 4 principles, the 4 Hardy-Singh principles, broadly meet the case, don't they?
Well, they
But
don't
I dare
meet,
say there might be a case where...
they don't meet with respect the requirement of foreseeability. We know in practice they don't. They are very useful principles because they are to the great benefit of those who are detained, deployed every day. But they do not provide for a statutory time limit. And secondly, there's no judicial oversight as well. So what happens is one is detained.
Well, point 2 suggests to me, at any rate, a finite period.
The question is, my Lord, whether or not it would meet the requirements of legal certainty. And we say that it doesn't. But I emphasise, before turning to my last point, that these arguments in relation to legal certainty are, of course, completely separate from the arguments in relation to discrimination and proportionality, albeit
Yes.
proportionality does have an element of legal certainty in it. I want to deal then finally with the point I kind of got slightly sidetracked on, which is at the outset, which is the question is, what is the test under the legislation? And if we look at the legislation as it currently is, which is in Authorities Bundle Volume 1, the test for detention, and it's at Divider 9.
Yeah.
And if I can ask you please to go to Regulation 21, which starts at the bottom of page 694, but the substance of it is at the top of page 695. And if you could keep a finger in that, and at the same time staying in the same bundle, go ahead to the Citizens Directive, which is at Divider 11. No, Divider 17. And please go to Article 27, which is at page 782.
Yep.
Now, the court has my point, which is a point on the text of this of the regulation, which is that a relevant decision is not defined to include a detention decision. All that one has is Regulation 24, which was amended, and I won't go through the fact that it was amended after my client was detained. That's a separate point. which is in our written case. But if one goes to Regulation 24, at page 701, it creates under 24.1 a power to detain if there are reasonable grounds for suspecting that a person is somebody who may be removed. We say that's a very low test if one considers Article 27. Bearing in mind, Article 28 concerns expulsion. We're dealing with other decisions, not expulsion. We're dealing with decisions pre-expulsion. We say that Article 27.2 requires an actual finding by the Secretary of State that the person's detention is necessary in order to protect one of the fundamental interests of society. Not some kind of interim decision, but we're dealing with detention. The detention, there's a final decision that one of the fundamental interests of society, which is the strict test in 27.2, one of those interests requires an actual detention. And we say that Regulation 24.1 falls woefully short of that. It simply requires a reasonable suspicion that someone might be deported. We just say it's not apt to meet the requirements under Article 27. And therefore, that's why Article 24 Regulation 24 and Regulation 19 are not compliant. If the court wants to try and interpret or seek to interpret these Regulation 21 in a way which is compliant with Articles 27 and 28, then it's open, as we say in our case, for the court to say all of the requirements, all the safeguards, and the very, very high tests under Articles 27 and 28, particularly the test under 28, the high test as regards permanent residence, all of that can be imported into, by a process of interpretation, Regulation 21. It's a hard point to unpick in two minutes, but I just make the point for the record, and the court will see this when it looks at Regulation 21, but Regulation 21 conflates Articles 27 and 28.
Well, you made that point some time ago.
Indeed.
The amendment to the regulations of time of detention.
Okay. And the last point I'm going to make, which is in our note concerning the statutory and factual context, it's paragraph 19, which is just so the court notes, and this was a point that was missed in the courts below, that at the time that my client was detained, in fact, Regulation 24 had not been amended to refer back to expulsion under 19.3b. You may ask, what's the relevance of all this? The relevance of this final point is that my client was unlawfully detained, either because the regulations themselves are ultra vires, or alternatively, if they're to be construed consistently with EU law, then the test for detention of my client was not satisfied. I'm sorry, I've taken slightly over my 2:30.
Hardly. Thank you very much.
Clock's a bit fast.
Sorry?
Clock's a bit fast.
Professor Tridimas. Mr. Ward.
Well, thank you. I propose to go through the statutory framework as briskly as I'm able to, but there are some important points of difference between us and the appellant, which are critical to the argument which follows. As the court will have seen, it is our case that in substance one answers the complaint of discrimination by reference to the wider legal framework, and therefore it is important that we see what it means.
Could you, just as a general point, it's clear that a lot of the points of being argued have been either not taken below or in a rather different form. If, as you're going, and I gather you don't object to any of that,
No.
but it'd be helpful if you could identify when we're dealing with a point which was argued below and which wasn't, so we know where we can find some help in one of the judgments below.
My Lord, I'll do my best. Mr. Orban, my learned friend, appeared below, so he's slightly better poised than I am to answer that question, but I will do my best. and there's no doubt that the arguments before your lordship and your ladyship are much more evolved and in some respects entirely new. And indeed, as a response, the Secretary of State's response is much evolved as well, although the core of our case essentially remains the same. What I'd like to do, if I may, is draw attention to 4 factors in the statutory framework. And the first is that a person who is not a British citizen and is not exercising EU law rights needs leave to enter and remain in the United Kingdom, an uncontroversial proposition. And just for the note, that proposition can be derived from Section 3.1 of the Immigration Act 1971, which is in the first authorities bundle under tab 16. And, of course, by contrast, a person exercising EU law rights has powerful rights to enter and remain, derived from, among other things, the Citizenship Directive. And this, as I will submit, bears directly upon the system of remedies for removal of such persons, where, as a matter of public policy, removal is justified. Now, what I'd like to do is just take a moment to show the court the rules, the immigration rules that govern the question of entry clearance. And we were mindful of the observation of Lady Hale in the BB case last week about the potential relevance of the present situation, as well as the situation as it was in 2012 when the contested detention took place. So over the weekend, we did put together a clip, including what we believe to be the correct version of the rules, both in 2012 and as it stands now. Not always a straightforward task, I must admit. And I hope that the court has a copy of that, which is white paper frontage, spiral bound in black, before you.
Just in case we didn't have enough paper. Thank you.
Well, it was with great regret that we added anything to the nearly 200 authorities already before the court. But may I show you the rules as they, under tab 1, are the rules which...
So this is the whole thing in a nutshell?
No. I'm pleased to say there's a very, very selective extracts from the immigration rules. But the first thing I'd like to show the court, if I may, is on page 9. And these are the rules. These are the rules in 2012, April 2012. Rules which governed grant of refusal of entry clearance, and indeed we'll see shortly revocation of...
What's the point about this? I mean, the differences, I suspect, between now and 2012 don't matter much.
They don't matter much. The short
point is...
The point I'm making, in fact, where this is going, is to just show how much more powerful the rights are of an EU national to be in the country in the first place.
That's not in dispute.
Well, my lord, if it may not be in dispute...
You say it's pretty fundamental part of your case.
I do, my lord, because it's part of the tapestry of powers by which the presence of undesirable persons in the United Kingdom is controlled. And I will be as brisk as I possibly can. But if I may, on page 9... refusal of entry clearance or leave to enter the United Kingdom. Under Rule 320, it says grounds upon which entry clearance or leave to enter is to be refused. And then over the page, on page 11, grounds on which entry clearance should normally be refused.
Yep.
And then it's sub-Rule 19 on page 12 at the bottom of the page.
Yep.
Where, from information available to the immigration officer, it seems right to refuse leave to enter on the ground that exclusion from the United Kingdom is conducive to the public good, if, for example, in light of character, conduct, or associations of the person seeking leave to enter, it is undesirable. That is, in our submission, as I will make good later, a much lower threshold than anything that applies in EU law. Whilst we are in this clip, because it will be very important to my argument shortly, over the page at page 14 are rules which govern leave to remain, once entry clearance has been obtained, but leave to remain, variation of leave to remain, or very importantly, curtailment of leave. So where leave has been granted, how can it be curtailed?
Yep.
And the important point for the present purpose is at 322 sub-rule 5,
Yep.
very similar rule, undesirability of permitting the person concerned to remain in the United Kingdom in light of his character, conduct, or associations.
Very well.
And just for the note, at 15A is Rule 323, which makes clear specifically that Rule 3225 governs the undesirability, governs curtailment of leave. Just for information as to the present position, that the current rules as enforced today are from page 17 and following. And in fact, what one can see is they have been tightened up. The scheme is the same, but the rules are tighter.
Is this an appealable decision under curtailment under 3225?
My Lord, one moment. I'm told that under the current regime, it's only appealable if one raises a human rights, asylum or protection claim. But the appeal rights have also changed considerably over the period that we're concerned with.
Tell me that.
We've tried not to get embroiled in that.
But in principle, it's appealable on human rights.
Yes. And then I was just about to take the court to the current rules, equivalent, and one can see the current Rule 320 on page 22 of the clip.
Yeah.
Grounds on which entry clearance is to be refused, and then there's a Rule 2, Sub-Rule 2, the court will see a sliding scale of offences.
Sorry, which one are we on?
I'm so sorry, my Lord, it's page 22,
Thank you, yeah.
Rule 322.
Yeah.
And this is new. Grounds on which entry clearance or leave is to be refused, Sub-Rule 2, currently the subject of a deportation order, convicted of an offence they've been sentenced to imprisonment of at least 4 years, convicted of an offence for which they've been sentenced to a period of imprisonment of at least 12 months, but less than 4 years, unless a period of 10 years has passed, has been convicted of an offence for which they have been sentenced to a period of imprisonment of less than 12 months, unless a period of 5 years has passed. Yeah. So there's a series of triggers there under the mandatory rules. And then one sees it also the familiar, if you like, fallback rule, which is at page 26. Very similar form to the earlier rule. Bottom of the page, sub-rule 19, character, conduct or associations. And then curtailment of leave. This time we can just look at page 29. Sub-rule 5, on page 29, the undesirability of permitting the person concerned to remain in the United Kingdom in light of conduct, including convictions which do not fall. I'm sorry, my lady, it's page 29. Sub-rule 5, the undesirability of permitting the person concerned to remain in the United Kingdom in the light of his conduct, including convictions which do not fall within paragraph 3221C, which is a set of the threshold types of conviction, character or associations, or he represents a threat to national security, or 5A, it's undesirable to permit the person to enter or remain because in the view of the Secretary of State, their offending has caused serious harm, or they are a persistent offender who shows a particular disregard for the law. So those are the rules as they govern both entry and curtailment
But these
of
are
leave.
new rules, not those at the time. The, ones we
The
just-
second set I just showed the court are the new rules. The first set are the rules at the time of the detention.
Yeah.
But by contrast, as the court will anticipate what I'm going to say, a person exercising EU law rights or free movement has powerful rights to enter and remain, derived ultimately from the treaty and then articulated in the regulation, the directive. May I just very briefly go now to the directive, which is in the main authorities. I'm now finished for now with my supplementary clip. And it's in Authorities Volume 1, and the directive is behind tab 17. And I'd like to start, if I may please, on MS page number 769.
Yes? Yep.
And what the court will see under Article 2, definitions, it's just useful to see that subparagraph 2, family member means, among other people, a spouse. Yes. Article 3, paragraph 1, this directive shall apply to all union citizens who move or reside in a member state other than that of which they are national and their family members. And we've referred to those in the printed case as people exercising EU law rights. Article 5, without prejudice to the provisions on travel documents, Member States shall grant Union citizens leave to enter with a valid identity card or passport, and shall grant family members who are not nationals leave to enter their territory with a passport. So that's a right of entry, subject to qualification, which I'll come to. Over the page, Article 6, Union citizens shall have the right of residence for a period of up to 3 months without any conditions or formalities. Article 7 deals with the well-established cases of exercise of free movement, such as worker, self-employed, student and the like, all subject to conditions, essentially as to recourse to public funds. And then Article 16 is the provision directly in issue in this case, which is the right of permanent residence. And that one can see on page 777.
Yep.
Union citizens who have resided legally for a continuous period of 5 years shall have the right of permanent residence. And then at subparagraph 2, that shall also apply to family members who are not nationals of a member state and have legally resided with a Union citizen for a period of 5 years, which is the case of Mr. Nouazli. And then finally, before we put the directive away, on page 782 are the core principles we're wrestling with in this case, namely Articles 27 and 28.
Yes.
Because they place restrictions on the ability to restrict free movement, are accordingly applicable both to entry and removal. And the point I make, I'm sure is clear, that this is much, much tougher threshold than the Secretary of State has been able to impose in respect of non-EU, people not exercising EU rights. And that's just very briefly, as I know the Court is familiar with this now. Article 27.1, the Member States may restrict freedom of movement and residence on grounds of public policy, public security or public health. Subparagraph 2, such measures shall comply with the principle of proportionality, be based exclusively on personal conduct. Previous criminal convictions shall not themselves constitute grounds. And then this is very important. The personal conduct must represent a genuine, present and sufficiently serious threat affecting one of the fundamental interests of society. That's the test Mr. Saini says must be fulfilled in every case. And then Article 28, protection against expulsion. At the bottom of the page, there's a set of mandatory criteria. Period of residence, age, state of health, family, economic situation, social and cultural integration, extent of links with country of origin. And then there are essentially 3 different threshold tests. There's, if you like, the ordinary test, which is that one must be satisfied that there is a present and genuine threat. And then there are 2 enhanced tests at 28, 2 and 3. At subparagraph 2, the host member state may not take an expulsion decision against Union citizens or family members, irrespective of nationality, who have the right of permanent residence, except on serious grounds of public policy or public security. And then an even higher threshold, in subparagraph 3, an expulsion decision may not be taken against Union citizens, so not Mr. Nouazli, but Union citizens, except if the decision is based on imperative grounds of public security, as defined by member states, if they have resided in the host member state for the previous 10 years, or they are a minor, except if the expulsion is necessary for the best interests of the child. So I respectfully submit there are 3 thresholds there, and they're all a very great deal higher than the kind of thresholds that apply to non-EU cases. This is directly relevant to the issues that the Court is asked to consider, because they bear directly on the measures for removal as well. Put simply, there is a greater ability to control undesirable persons from entering the United Kingdom in the first place, and a greater ability to remove them. Now, my second point concerns curtailment of leave. I showed the Court the relevant rules whilst we were in the rules, and I showed you that the rules impose a threshold much, much lower than under the EEA regime. But what's very important now is, if I may, show you a little bit more of the statutory mechanics to explain why there is a power to detain very closely analogous to Regulation 24.1. Now, this is an important submission because you heard Mr. Saini say that Regulation 24.1 was novel and that there was no analogue
Yes.
in the regime that applied to non-EEA cases. In our respectful submission, that is wrong.
Right.
And I'd like to show the court now why.
Yep.
And the relevant legislation is under tab 4 of bundle A1 on MS page 617.
Yep.
And this is the Immigration and Asylum Act 1999. And I do have to ask for your patience in dealing with what is a little bit involved. Section 10(1)(a).
Yep.
A person who is not a British citizen may be removed from the United Kingdom in accordance with directions given by an immigration officer if, having only a limited leave to enter or remain, he does not observe a condition attached to the leave or remains beyond the time allowed by the leave. And then just over the page, at 10.7, it says, in relation to any such directions, I'll just draw your attention to paragraph 16 of Schedule 2 to the 1971 Act.
Thank you.
Applies as if it applies in relation to directions given under paragraph 8 of that schedule. I'm going to take you to that, of course, in a moment. But the important thing to understand, as we explained in our printed case, is that where leave is curtailed, a person enjoying limited leave to remain has that leave come to an end. And what happens is, therefore, there is no longer leave for them to stay in the United Kingdom. And if they remain in the United Kingdom, they are in breach of their conditions of a leave. And they will have remained beyond the time limited by the leave in the language of Section 10(1)(a). Now, the consequence of that, as you've seen, is there is a reference back to Schedule 2 to the 1971 Act. So if I may, I'll take the court to that now. And Schedule 2 is under tab 1,
Yep.
and it begins on page 561, but the
We go
first...
to 570, do we?
My lord, yes.
Thank you.
Thank you. 570
Right.
is Schedule 2, paragraph 16, subparagraph 2.
Right.
And it's the bottom of page 570. And it says, if there are reasonable grounds for suspecting that a person is someone in respect of whom directions may be given under any of paragraphs, and you'll recall paragraph 8 is specifically referred to, that person may be detained under the authority of an immigration officer pending a decision whether or not to give such directions. And just to complete the picture, if we turn back a couple of pages to 567, we see Rule 8, which is where a person arriving in the United Kingdom is refused leave to enter, an immigration officer may give the captain of the ship or aircraft directions requiring him to remove. And what's said, in effect, in the 1999 Act is this mechanism applies in the case of removal directions where leave is curtailed.
And 16.2 has, it looks as if the wording of 24.1 as substituted by paragraph 10 of Schedule 1 to the 2009 regulations was taken from paragraph 16.2.
It's strikingly similar, and this paragraph 16 has been on the statute book a great deal longer.
Sorry, when was this? Paragraph 2 was added by amendment at some point, do we?
Paragraph 2 of what, my lord?
Well, on page 570, the 116.2 is in brackets, square brackets, which suggests that it's come from somewhere.
It was substituted by the 1999 Act. You look at page 590.
Oh, I see.
I'm very grateful. I knew it wasn't very recent, in a way that would be fact-sensitive in our case.
You think that that is the source of the provision we're talking about in this case?
Well, my lord, I
Or
can't
maybe, but
I can't go further than saying the drafting is strikingly similar. The
it's
practical
obviously
effect
a statutory precedent for the similar
Yes.
wording,
yes.
and no one spotted that before this level.
Well, my lord, the argument is a
The
completely...
arguments have changed before.
Well, I want to be clear, though, as well, what this does not show. I'm not suggesting that this provision on its own is a complete answer to
No.
Mr. Saini's case. If that were so, there wouldn't be a 70-page printed case in front of you. It would be as simple as that.
But it's a start.
It's
But I mean, I wasn't criticising anyone. I was just
No, no.
surprised that this hasn't been referred to before,
Well,
as far as I know.
my lord, the arguments have evolved on both sides. But the other thing I do want to draw attention to make clear, is that this mechanism I've just shown the court applies to somebody with limited leave.
Yes, yes.
It doesn't apply to someone with indefinite leave to remain.
No, it's a more limited class of person in practice.
Yes.
Yep.
So, but what the rules also tell us is something about indefinite leave and the conditions on which it can be granted. Because actually one of the arguments that Mr. Nouazli has made in his submission, his written submission, is that, well, perhaps a person with indefinite leave to remain is the correct comparator for him. Now, we spent a lot of time at the weekend trying to work out what on earth would have been the right set of rules on indefinite leave to remain to apply. It was an impossible question to actually answer. But in a nutshell, the rules on indefinite leave which apply now are also concerned with questions of conduct. And I can take the court to that if it would be of assistance, but perhaps just for the note, we included some examples of these rules as they are now and as they were in 2012. We can't go further than that because trying to come up with a counterfactual about Mr. Nouazli, if he'd had limited leave to remain, what was the status of his wife, and so on and so forth. But there is reference back to conduct-related issues. So it's far from evident at all that on that counterfactual, Mr. Nouazli would have had indefinite leave to remain at any stage, or that he can be sensibly compared to somebody with indefinite leave to remain. I want to go to my third topic now, which is deportation. Now here, there are a range of statutory powers, and there's not much disagreement about this, so I'll take it very quickly. The provision that is, in a sense, at the centre of Mr. Nouazli's claim is Section 35A of the Immigration Act, which gives the Secretary of State power to deport where deportation will be conducive to the public good. And I make the, I think, anodyne uncontroversial submission that that is also a lower threshold than anything that we see in the directive. And in our printed case, at a bundle reference in the core volume on page 129, paragraphs 34 to 36, we set out some case law, simply expressing the extent to which there is deference to the Secretary of State's view in this area and the amount of emphasis that is placed on the policy in favour of deportation.
Sorry, repeat please the paragraph numbers in your case.
My Lord, I'm sorry. It's printed case paragraphs 34 to 36.
Sure.
And it's bundle CV page 129. So it's a much lower threshold again. Then there is a power. There is a power relating to judicial recommendation. We don't put that in issue in the court now. It's very rarely used. There's some debate about whether it could apply to EU nationals. On the current law, it does. But again, we don't wish to really advance a case based upon that. But the other provision that is important, which I do have to show you, is the the UK Borders Act 2007, which deals with automatic deportation. And may I take you to that back in Bundle 1 under tab 7? Because this is another element of the regime which is much less favourable to non-EEA cases.
This is why court recommendations have become a thing of the past.
It's exactly so, my Lord, exactly so. And that proposition can be derived from the case Cluxon, which is, it's in our printed case somewhere. But so the UK Borders Act, under tab 7 of Bundle 1, starting on page 641, what it provides in a nutshell, before I take you through the provisions, is automatic deportation of a foreign criminal as defined, unless they can establish a statutory defence, one of which is exercising relevant EU law rights. But it is worth taking a little bit more time than that, if I may. And Section 32 has a definition of foreign criminal.
Yes.
A person who is not a British citizen, who is convicted in the United Kingdom of an offence and to whom Condition 1 or 2 applies. And Condition 1 is that the person is sentenced to a period of imprisonment of at least 12 months. Now, Condition 2 is not in force, and this is one of the few points in the appellant's note on statutory provisions we agree with, and we're grateful for a correction to something we said erroneously in our printed case. So that's the person who is a foreign criminal. Then Section 32(4) says, for the purpose of Section 35A of the Immigration Act, the deportation of a foreign criminal, as defined, is conducive to the public good. And then Section 32(5), the Secretary of State must make a deportation order in respect of a foreign criminal subject to section 33. So he must make this, if we are dealing with a foreign criminal, subject to section 33 over the page, which contains a series of exceptions, forgive me, and the ones perhaps just worth bearing in mind are 33.2. Exception 1 is where removal would be in breach of a person's convention rights or under the Refugee Convention, and then 33.4, where removal would breach the rights of the foreign criminal under the EU treaties.
Yep.
So that's an EU exception.
Yes.
So what the Secretary of State must do is decide, is this person a foreign criminal? Which, pausing there, is likely to be a straightforward question. If they have been so sentenced, it ought to be straightforward to understand what their nationality is. But I understand there are cases, occasionally, where that can be not a completely straightforward question. And then if they are a foreign criminal, the Secretary of State has to consider whether any of these statutory defences applies. So if a person is an EU national, exercising EU treaty rights, very importantly, then they fall out of the automatic deportation regime. And the court will have seen, when I went through the directive, that the directive specifically says that a past conviction is not a sufficient basis on its own for deportation. But the part that's, of course, very important for the present argument is then the power of detention which goes through this, which is in section 36 on MS page 645. And what that says is a person who has served a period of imprisonment may be detained on the authority of the Secretary of State while the Secretary of State considers whether section 32.5 applies. So he has to decide, or rather he can detain while he decides whether this person is a foreign criminal, if that's in the least bit in issue, or alternatively, more plausibly, whether these statutory defences are made out.
Yeah.
In other words, is there a human rights claim? Are they indeed exercising rights under the EU treaty? So that, we do say, provides a measure of analogy in more serious cases to the power we are considering under Regulation 24.1. We do not say it is exactly the same. We take the force of the point that there is essentially a deeming provision of conducive to the public good once it's clear that someone is a foreign criminal, but nevertheless there is a pre-decision detention whilst these fact-sensitive matters to do with, for example, human rights are considered. And to that extent, at least, there is a degree of analogy. And then for completeness, 36.1b says where the Secretary of State thinks that section 32.5 applies, pending the making of the deportation order. In other words, pending the mechanics of execution of the deportation order.
Now, there are no provisions here about the time that that's to take.
Well, there is one provision, my lord, in fact, and I think it is section 34.1. Section 32.5 requires a deportation order to be made at a time chosen by the Secretary of State. So not massively illuminating. But
Well, that doesn't tell you, the Secretary of State, how long the Secretary of State's to take.
no. But as to the duration of detention, as I will submit later, that Hardy or Singh will apply with relevant modifications, and indeed there is call for appeal authority to that effect on this working of this Act. So we say there is, therefore, so far there are three provisions I've really sought to draw attention to. One is controls on entry. The second is administrative removal under associated
Now,
power of detention.
sorry, the rationale of 34.1, giving it to the Secretary of State, is the practical one, isn't it? That the person qualifies for automatic deportation. They don't have any home-based human rights articulation or anything of that sort, but at the moment the government can't charter a flight to get them back to such and such country because of the state of turmoil.
May I take instructions, my lord? The answer from behind, from the Home Office, is yes, but another reason it might be done that way is if there's another prosecution in the pipeline, which applies to this particular defendant as well.
Right. Yep.
And one of the points in the
Well, I
appellant's
suppose
note-
conceivably they might be a prosecution witness.
that's conceivable too, my lord. It certainly allows for some flexibility, but there's a piece of very, very careful drafting on this that's in the appellant's note on the law, the supplementary note on the law, where they say paragraph 3, I can just read it out. Nor could the UK Borders Act have applied to the appellant, even if he had not been the family member of an EEA national, at the time of his impugned detention, because the conviction in respect of which his deportation was then pursued attracted a sentence of less than 12 months. That's careful drafting, because in December 2008 he was convicted to various offences and sentenced to 23 months of imprisonment in total concurrently. And I'll come back to that shortly. There's one other point that I want to just mention and then not spend any time on. Things have moved on again in the world of immigration control. In our supplementary bundle, we put in some up-to-date guidance which shows that under the latest statutory provisions, there is, rather under the guidance that reflects the latest statutory provisions, there is in fact the opportunity for a defendant, or rather a subject of this kind of removal action, to make further representations between the date of the decision to deport and before a deportation order is actually made. We haven't troubled the court with all of the statutory clockwork, and I don't propose to either develop it or really rely on it. But mindful of what Lady Hale said in BB, we wanted to at least mention it. Now,
Oh dear, I've such a lot to answer for.
Well, we kept us busy over the weekend, my lady. The fourth point I was going to make on the statutory framework is almost really a summation of what I've said by distinction of the position under EU law. A person exercising EU law rights is in a highly privileged position. They have powerful rights of entry and residence. They are not subject to a requirement of leave to enter or remain. They can't be removed for breach of a condition of leave. They're not subject to the associated powers of detention. They're not subject to automatic deportation. Instead, they have protection against removal and deportation on public policy grounds, as set out in Articles 27 and 28 of the Directive. There has to be an individual assessment. It must not be based solely on past convictions. It is essentially forward-looking. There is a need to assess what past conduct implies about the future. And there is a high threshold test, much higher than applies in the case of a non-EEA national. And it's against all of that background, we submit, that Regulation 24.1 must be seen, because it provides a power to detain if there are reasonable grounds to suspect that someone may be removed from the United Kingdom under the directive machinery. As I've already submitted, that is strongly analogous to Schedule 2, paragraph 16.2, albeit that the threshold is much higher, because of course we are dealing with removal under the directive. So we don't say it's identical to any power under the non-EEA regime. I've accepted that it only applies where there is limited leave. But what this review of the statutory framework is intended to show is that there are essentially somewhat different ways of dealing with the same policy objective, which is keeping the United Kingdom free of persons who are undesirable and effecting their removal, if they are here. And those different policy tools very clearly derive from the nature of those EU law rights. Now, what Mr. Saini said this morning is he made an allegation of difference of treatment put at a very high level of generality, where he said, well, an equally dangerous American, to Mr. Nouazli say, could not have been detained. But in my submission, that is an extremely question-begging formulation, because the court will have seen Mr. Nouazli's particular case, a long pattern of offending. What we have to envisage is a proposed comparator who is a non-EEA, a person without EEA rights. So an American is a perfectly good example, as Mr. Saini suggests. But he has to have the following 5 characteristics. He must not have been refused entry in the first place due to past conduct issues. If he was on limited leave to remain, his conduct would needed to be good enough that that limited leave would not be revoked. And if it had been revoked, he could have been subject to detention. Then he would have had to have applied for indefinite leave to remain and satisfy the conditions, including any relevant conditions as to conduct. But then, if we are to imagine a counterfactual to Mr. Nouazli, he must then have gone on a crime spree of sufficient seriousness that he would have been subject to detention under Regulation 24.1 because there were reasonable grounds to believe he might be removed under the requirements of the directive. But yet, on the other hand, that conduct must not have been so serious that he would have been subject to automatic deportation and its power of detention. Now, I'm not making the submission that that is an absolutely impossible case, but what I am submitting is it's essentially a hypothetical case, and that for Mr. Saini just to say, what about an equally dangerous American, just fails entirely to grapple with the wider context of the statutory regime. Now, in the appellant's particular case, he certainly can't establish any kind of comparator, because as we've submitted, and as Lord Toulson adverted to this morning, he would in all likelihood have been automatically deported a long time before any of these events took place. And that is because he was sentenced to 23 months of imprisonment on the 15th of December 2008. Now, we were surprised this morning to hear Mr. Saini say, well, that may not be so because he had an asylum claim. Now, we're aware he'd advanced a claim based on human rights, which had been essentially on the basis that he had had children with his former wife. In fact, it may be useful just to turn it up very briefly to see the nature of the human rights claim. It's in Appendix 2, where we can look at the tribunal decision that was taken just a few weeks before he was, in fact, convicted and sentenced to 23 months imprisonment.
Page.
It's in Appendix 2 at page 118. 117 is the beginning of the decision.
Yep.
And there's actually a rich irony about this, indeed, because this is a tribunal decision which quashed an earlier decision to deport Mr. Nouazli, precisely because the tribunal found he should have been dealt with under the EEA regime. So his EEA rights defeated the attempt to deport him on that occasion. But it also articulates a human rights claim by Mr. Nouazli at that time.
Have you got an electronic page reference?
My lady, I'm sorry, it's just numbered 118 at the bottom of mine. I'm so sorry. Appendix Part 2, I'm told, isn't in the electronic version. Is that something we can remedy?
It is.
Can we try? Well, my Lord Newberger says it is.
Well, Appendix Part 2 does seem to be in the...
Well, there's bundle numbering, although it doesn't say MS in front of it.
This is a regular problem. The bundle numbering doesn't necessarily correspond to the MS numbering, and many
Appendix Part 2 is in the electronic bundle.
Well, that's at least some progress.
Yes.
Well, it was in bundle page numbering, I was taking you to 117.
Well, that's of no use at all. What's the tab number?
I don't have tabs.
doesn't seem to have tabs.
I'm so sorry to...
MS314.
MS314 I'm offered from behind.
That's
Mr. has a marked up copy, which I will now use, if I may. MS314, yes.
That's brilliant.
Oh, I'm so pleased. Right. So this is the tribunal's determination in November 2008, in which it quashed an earlier attempt to remove Mr. Nouazli. And if one skims just to the end of it, the basic reason was they concluded that he couldn't be removed under the EEA regulations. So here was Mr. Nouazli staying in the country on the basis of his EU law rights, in fact, just a matter of weeks before his conviction and sentencing for 23 months of imprisonment.
Which paragraph do you want to take us to? Sorry.
I wanted to show the court, firstly, paragraph 12,
Right.
where what was advanced was a human rights claim that he would lose contact with his children who were in foster care in France if he were removed to Algeria.
Yeah.
But what we also see is that the basis of this claim was explained at... Sorry, one moment, I have the wrong reference. It's paragraph 30. Where what's explained, and in paragraph 30 is an extract from the evidence, and it's on MS page 321, where what's explained essentially is that Mr. Nouazli had children by his wife, but she had left, and the children had gone into care, some in the UK and some in France. And then later, the children in the UK were also put in care in France. So what the human rights claim essentially amounted to, and very importantly, that he wasn't actually seeing them at that time. Yeah. So the human rights claim in our respect...
There's no asylum claim.
And think not, we were checking at lunchtime. It's true that he claimed asylum on his arrival, and we can see if you look at paragraph 1 of this determination, it says he claimed asylum which was refused, and his appeal against that decision was subsequently withdrawn.
That's back in 96.
Yes. So Mr. Saney hasn't sought to suggest he has a human rights claim that could have defeated automatic deportation. What we had instead was, for the very first time, and I can certainly confirm this to my lord, it's never been suggested before that his asylum, some sort of dormant asylum claim, was a reason why he might have been defeated his deportation.
Well, Mr. Sane is shaking his head. So,
My Lord, my only point was to address one of the points that my Lord Tilton made, which is, he would have been removed a long time ago. One can't make that assumption, because there was an asylum claim. It wasn't pursued because Mr. Nouazli had other rights. But one can't assume.
All we know is he had an asylum claim, didn't pursue an appeal, and by 2008, all he was asserting was a human rights claim.
Indeed, that's the only point. But one can't make any assumptions as to what would have happened.
Why not?
In the past.
Sorry, never mind. It's not.
The submission we've made, which we stand by, is we didn't say it's absolutely categorically the case he would have been deported. We said in all probability he would have been. And what I hope I've shown the court is that he benefited powerfully from his offence, of which he now complains of discrimination. And against that statutory background, I'd like...
Can you just help me on,
My Lord.
while looking at Article 27, do you accept that the principles of Article 27 have to be imported in to the decision whether to detain him?
Well, jumping ahead
Or does that come to later?
I will come to that, but
We'll
our
come back
submission
to
is, I'll just prefigure my submission, my Lord. Our submission is, it is sufficient that there are reasonable grounds to believe that a deportation will take place, which will itself comply with Article 27 and 28. But if I may, I'll come to that when I deal with the last part of Mr. Saney's case. Because, put it bluntly...
Come back to it later.
My Lord, if that's convenient. I wanted now, having dealt with the statutory framework, to go now to make some legal submissions on discrimination. And I confess we were surprised to hear this morning that the common law was put at the absolute forefront of my learned friend's case, because the written submissions put EU law firmly in the forefront. And indeed, that we were aware there was a reference to Matadine and Pointu and one or two other cases at page 21 of their case. But the reason why there has been a change of heart is there are insuperable difficulties to the claim in EU law under the existing case law of the Court of Justice. And despite the fact that nearly 200 authorities have put before the court, there is not one which is good for the kind of propositions that Mr. Saney has sought to advance about the scope of EU discrimination law. And as to that, I just want to make three very high-level points before embarking on the core authorities, which I hope to be able to do well before 4 o'clock. The three high-level points are these. Firstly, the appellant has not begun to show that that power is invalid in its entirety and can never be used, which is the avowed ambition of this claim. And in the language of Lord Hodge in Ali and Beebe, it is not a power that is incapable of being operated in a proportionate way or inherently unjustified in all cases. And just for the note...
Well, I think I said the same in Ali and
Very
Beebe.
similar, I think, paragraph 58, my lady. It's clear in this case that there are a large number of cases outside the EEA framework where there will be a power of pre-decision detention, for reasons I've already explained. But secondly, at the very centre of the legal argument is the contention that EU anti-discrimination law precludes differences in treatment between a person within the scope of EU law and someone who is not. That is simply wrong in principle and contrary to authority. And then the third thing I was going to say by preliminary observation was very much mindful of an observation of Lady Hale in Gaidan and Godin Mendoza. We do accept that our discrimination case could be put in, frankly, under various different heads of the rubric of anti-discrimination law. And we've expressed it in a certain way, but as Mr. Saney said, in fact, the same points can be put whether as objective justification, comparator, or so on. But let me start then with what I say is the insuperable objection of principle. EU law does not preclude a difference in treatment between a person within its scope and a person outside it. And the essential reason is that EU law does not seek to equalise the position inside and outside EU law. Because if it did, then the member states would be obliged, as a matter of EU law, to justify any difference of treatment between the scope of situations in its scope and situations without not. Now, if that really was the law, you would have thought that somewhere in these 200 authorities would be a case that said so, or even an example of that in action. And in fact, there are none. And in fact, I'll show you in a moment, there's an authority powerfully to the opposite effect. Right. But it is worth dwelling on just how powerful an expansion of EU law that would really be if that kind of objective justification was required in every case. And the most important authority in this context is a case called Vatsouras, which has featured heavily in our printed case, but I'd like to take a moment to show it to the court, if I may. And that's in the 10th authorities bundle under tab 124. I can take you straight to the judgment and indeed to the operative part, where we can see on MS page 3664.
Which bundle, which tab?
I'm so sorry, Molo, it's volume 10.
I apologise. Yeah.
And it's tab 124.
My lady. Thank you. Yep.
And this was a complaint by Greek migrants to Germany that they were unable to access a benefit which was actually available to certain types of illegal immigrant. So they were complaining, just like Mr. Nouazli, that they were worse off because of the exercise of EU rights. And we can see the very short passage in which the Court of Justice dispatches this argument.
Yep.
And it starts at paragraph 48, where they formulate the issue. By this question, the referring court asks whether Article 12 EC precludes national rules which exclude nationals of member states from receipt of social assistance benefits which are granted to illegal immigrants. Now, can I ask you, in fact, to keep your finger in there, and then we can just look at Article 12, which is quoted in Vatsouras, and therefore we needn't look it up elsewhere. And it's at page 3642, the bottom of the page.
Right, that's in the Advocate.
It's actually in the Advocate General's opinion. It's just conveniently quoted, my lord.
Yeah, I understand.
So the bottom of the page, Article 12, which now is known as Article 18 TFEU,
Right.
but the wording is identical.
Thank you.
At least for the first paragraph, is identical. Within the scope of application of this treaty, and without prejudice to any special provisions contained in, any discrimination on grounds of nationality shall be prohibited. So it's quite general in its overt language. But the court said, this doesn't help you. It doesn't help the Greek men in Germany complaining about social security. And if we now could turn back to the judgment, paragraph 50, I showed the court the question a moment ago, and then the Court of Justice, of course, somewhat reformulates the question. The question should therefore be construed as meaning that the referring court is essentially asking whether Article 12 precludes national rules which exclude nationals of member states from receipt of social assistance benefits in cases where those benefits are granted to nationals of non-member countries.
Isn't that funny? That's almost exactly what's said in paragraph 48.
Oh, there must have been some,
Why did they bother?
maybe drafting by committee. The first,
Is this a chamber or a... No, it's a chamber.
it is a chamber.
Third chamber.
But I suppose one says all chambers are distinguished in the Court of Justice, but this one certainly is. The first paragraph of Article 12 prohibits, within the scope of application of the EC Treaty, and without prejudice to any provisions contained therein, any discrimination on grounds of nationality. That provision concerns situations coming within the scope of community law, in which a national of one member state suffers discriminatory treatment in relation to nationals of another member state, solely on the basis of his nationality, and is not intended to apply to cases of a possible difference in treatment between nationals of member states and nationals of non-member countries. So there's actually two problems for the appellant in there. Because firstly, it's talking about comparators between nationals of one member state and another. And as my Lady Hale said in the Pat Malnice case, only the nationals of member states are protected. And just for the court's note, that's in Authorities Bundle 4, tab 52, at page 1686, paragraph 83. But secondly, and really more fundamentally, it doesn't extend to situations outside the scope of community law. And before we put it away, the Advocate General expressed the same proposition at an even higher level of generality, not derived from the language of Article 18 in any way. And we can see that at page 3652. Paragraph 66.
That's the Advocate General.
Advocate General, where he says, in relation to the third question, community law does not provide rules for resolving issues of differences of treatment between community citizens and citizens of non-member countries who are subject to the law of the host member state. Well, that is just a fatal blow to the argument advanced by the appellant in this case. The comparator he seeks to rely on is wholly outside the scope of EU law, namely the hypothetical American. Now, one thing to bear in mind, though, in his favour, I want to make clear, is that Article 24 of the directive contains a specific non-discrimination law, which is based upon Article 18, but is slightly wider, but not in a way that actually helps him. So if we can now put that away, that SORAS, but pick up again the directive. It's in Bundle 1 under tab 17. And this time I'd like to go to MS page 781. This is Article 24.1, which is, as quite often happens in EU law, a specific enunciation of the principle of equal treatment. And here it says, subject to such specific provisions as are expressly provided for in the treaty and secondary law, all union citizens residing on the basis of this directive in the territory of the host member state shall enjoy equal treatment with the nationals of that state within the scope of the treaty. Yeah. But here's the bit that helps him slightly. The benefit of this right shall be extended to family members who are not nationals. So unlike Article 18 TFEU, I accept that in principle Mr. Nouazli can rely on this. It's just no use to him, because all it does is guarantee him equal treatment with the nationals of the host member state. It says nothing at all about Americans. Now, that is, in our submission, a fatal blow to the case based on EU law. There is also an argument that we've also observed that the same result is reached in cases of the Strasbourg Court, including Mustaqim and Belgium, albeit that the point is articulated in a slightly different way, where, as you heard, I think, already this morning, they say that viewed as a matter of objective justification arises because EU rights flow from a special legal order. Now, Mr. Saini has argued that the Belmarsh case shows that that line of authority is no use to us. But in my respectful submission, that is a misreading of the Belmarsh case. Because in that case, what the House of Lords held is that the immigration status of the various people who were detained was irrelevant on the facts, because that provision had nothing at all to do with immigration control. We are squarely concerned with immigration control. But may I just show the court the crucial passages with that in mind?
Yes.
It's in bundle A3 under tab 40.
Yep.
And it's the same passages you've already seen, in fact, but we do put a slightly different emphasis on them.
Yes.
So the first page is MS 1357 from the judgment of Lord Bingham.
Yes.
And at the bottom of paragraph 53, just for context, to remind the court what was really under discussion, suspected international terrorists who are UK nationals are in a situation analogous with the appellants because they, in the present context, they share most of the relevant characteristics, one of which was, of course, they couldn't be removed. And then we see at the bottom of the page 55, the Attorney General made a more far-reaching submission. He relied on the old established rule that a sovereign state may control the entry of aliens into its territory and the expulsion from it. He submitted the convention permits the differential treatment of aliens as compared with nationals. See Mustaqim. But what Lord Bingham said is He then quotes summarises the effect of Mustaqim, says it's indeed obvious in an immigration context some differential must inevitably be made between nationals and non-nationals, since the former have the right of abode and the latter do not. But then very importantly at the end of the paragraph, the question is whether and to what extent states may differentiate outside the immigration context. And the answer was they couldn't, because it was unjustified. And we see precisely the same point articulated by Lord Hope, and this time again, the passages Mr. Saini showed you, starting on page 1374 this time.
Yes.
Paragraph 103, it's a very similar effect.
Yep.
The right of the state to control immigration has, of course, long been recognised in international law. It forms the background to Article 5.1f of the Convention, which is the provision that allows detention pending removal, precisely what we're concerned with. This is why a contracting state is permitted to deprive aliens who have no right to be in the country of their liberty for the purpose of preventing their unauthorised entry or with a view to deportation. Well, that's what's happening here. But it would be a serious error, in my opinion, to regard this case as about the right to control immigration. This is because the issue which the designation order was designed to address was not at heart an immigration issue at all. And then at 105, the Secretary of State was of course entitled to discriminate between British nationals on the one hand and foreign nationals on the other for all the purposes of immigration control, subject to the limitations in the Chahal case. What he was not entitled to do was to treat the right of liberty under Article 5 of the Convention of foreign nationals who happen to be in the country for whatever reason as different in any respect from that enjoyed by British nationals. And this has given rise to, in my submission, a very bad point by the appellants, that Mustaqim in some way is only about only allows a discrimination as to liberty in the context of expulsion, but not detention. Because Lord Hope is saying there, the right to liberty applies equally. But of course, the critical point is that in the Belmarsh case, the court is saying immigration control is irrelevant to this case. That is why they distinguish away Mustaqim. Whereas in our case, it's precisely on point. And just for the court's note, Lord Roger at paragraph 171 is to very similar effect. So this tells us nothing at all about the legitimacy of distinguishing between two groups of third country nationals for immigration control purposes. Now that also provides the answer to a point made about Lady Hale's observation in the Tigger case that immigration status can be a status for the purpose of Article 14, status-based discrimination. We don't dissent from that proposition, as Mr. Saini suggested we wouldn't. It just, in some cases, it will be a legally irrelevant consideration, just as it was in the Belmarsh case. But what we're submitting in this case is that what's being sought is an illegitimate comparison between isolated elements of two different systems for control, entry, removal, and detention. Nothing in the Belmarsh case defeats that argument.
It's quite difficult to know quite where you draw the line between that which is an immigration issue and that which concerns an alien's right to liberty. One could imagine circumstances where the answer to that question would not be a very obvious one.
Well, my lord, I mean, obviously that was a point that remained an issue as far as the House of Lords in the Belmarsh case. Yeah. So I accept it could be a difficult question. And the Attorney General made a submission in the House of Lords that the court rejected.
Is it, I was reading on to see what Lord Hope said in 104 and 105. Is it that as long as there is a prospect of removal, which detention is in support of, then you don't classify it as about right to liberty. It's all about immigration control. But the moment you have accepted that removal is no longer practically possible, thereafter detention ceases to be within the immigration umbrella where you can discriminate and different principles apply?
Well, my lord, I wouldn't characterise it that way with the greatest of respect.
No, well, fine. How do you characterise it? I'm
the
just
way I would
trying
characterise
to
it is
see
this.
how
Yes.
how it cuts.
In the Belmarsh case, what the House of Lords was saying is this particular detention is an anti-terrorism measure applied to people who cannot be removed from the United Kingdom. Therefore, it has nothing at all to do with immigration control. And they contradistinguished precisely the kind of power we are concerned with, which is a power to detain purely for the purposes of removal for immigration control reasons. And the essential point, in fact, I think we can find it. If I can show, my lord, if it may be helpful to see what Lord Bingham said at paragraph 52 of his judgment, where another submission of the Attorney General is rejected.
No, I mean, I think you've answered my question. You say that it was done by characterising the nature of the measure.
Yes.
And the measure wasn't seen as ancillary to immigration control.
Exactly.
The measure was seen as purely, simply an anti-terrorism measure.
Yes, and just for your lordship's note, paragraphs 52 and 53 of Lord Bingham's judgment really deal with that point, where his lordship rejects a submission from the Attorney General, which was there was a relevant immigration control difference. Perhaps I can just take you to it. It's at MS 1356. The Attorney General submitted the position of the appellant should be compared with that of non-UK nationals who presented a threat to security who could be removed to their own or safe countries. The relevant difference between them and the appellants was the appellants could not be removed. A difference between the two groups was accordingly justified and it was reasonable and necessary to detain them. By contrast, the appellant's chosen comparators were suspected international terrorists who were UK nationals.
Yeah.
The appellants pointed out they shared with this group the important characteristic of being international terrorists and being irremovable. And then Lord Bingham says at the end of 53, I agree, they're comparable.
Right.
So it's just gotten, the point is it had nothing to do with immigration control.
Indeed, had they been able to get rid of them through immigration methods, they would have done years ago.
Very gladly.
What the problem was.
Exactly. So just very briefly, before moving on to the next head of the appellant's argument, another thing Mr. Saini said is that none of this is of any help to you because we're not complaining about a benefit available under the treaty only to EU nationals. We're complaining about a detriment arising out of something that was essentially optional. Regulation 24.1 is not required by EU law, it's just permitted. But Vatsoras itself is an answer to that point, because Vatsoras was also about EU nationals complaining they were worse off, and they were worse off because they did not enjoy these social benefits which were available to illegal immigrants. But nothing in EU law required that outcome either. So does it help Mr. Saini then to put this part of his case on the basis of the Charter of Fundamental Rights or the general principles of EU law? Our answer is no, for the very simple reason that it runs up against the same conceptual objection. Whether it's packaged as charter or whether it's packaged as general principles, it still involves a comparator to someone who's wholly outside the scope of EU law. And nothing at all in any of the hundreds of cases before the court shows that such a comparator is in fact permissible. So yes, the Charter talks in general terms about the principle of equal treatment, and so do cases on that general principle. But it's general equal treatment within the scope of EU law. Now, I can make that good in a little detail, but in a sense I'm proving a negative, that there's nothing to say that is, there's nothing to demonstrate that I'm wrong. But of course, if general principles of EU law really made a difference here, well, surely that's what the court would have said in Vatsoras. It would have said, well, Article 18 can't help you, but general principles of EU law, which have been in the court's case law for decades, we can bring those to bear. Now, what Mr. Saini says about that is, well, it wasn't argued. But of course, that's just, frankly, no obstacle. In the authorities bundle is, in fact, a case you may be familiar with called Sturgeon, where the ECJ construed a directive which gave rights to compensation to passengers for cancelled flights. And notoriously, the ECJ decided there was also a right to compensation for delayed flights. But that wasn't even a question that was asked of it. So I don't accept that there's any inference that can be drawn from the fact that, well, in Vatsoras they were only asked about Article 18.
Well, the fact the court sometimes goes further than it's asked to go doesn't mean that because it wasn't asked to go further, or it doesn't go further, you assume that hasn't occurred to it. I mean, the point may not have occurred to anybody, and it's now says Mr. Saini, it's occurred to him, and he's running it.
Well, in my submission, if he was right, the point was so blindingly obvious.
That I understand.
It's hard to conceive that the court wouldn't have said so. And if we look at the charter a little more closely, I can probably deal with this in about 5 minutes, so I hope it's good use of the court's time. It's just worth turning up the
You're
charter.
the one with limited time.
My lord?
You're the one with limited time. Yes.
I appreciate that. But I
Anyway,
see
if
he
you
says
want to
this.
spend 5 minutes on it, that's fine.
Thank you. If we go to Supplementary Bundle of Authorities, A15,
A15, yeah.
behind... In fact, sorry, we'll go to A1. I'm so sorry, then we can see two things in one place.
Thank you.
The version of the charter under tab in volume A1 is in fact incorrect, but I don't think it will matter for this
Does it
purpose.
matter?
I don't think for this purpose, no.
Well, that's
I
in
hope
that
not.
case. Because the provisions we were taken to before by Mr. Saini were all the same, and one of them wasn't in the other bundle.
There are some differences that are in the details.
Will they
of the-
matter?
But for right now, this will make no
Right.
difference. So it's
Article?
it's tab
Yeah,
15, and it's page 740.
right, and Article,
21,
thank you.
and this is the non-discrimination provision.
Oh yeah, we looked at that.
And we've already looked at it. And what you'll see now is clear, is that Article 21, subparagraph 2, repeats the effect of Article 18 TFEU.
Yes,
And Article 21.1 is a general provision on prohibition on discrimination. But there's nothing to suggest that Article 21.1 can somehow expand the scope of the cases which fall within EU non-discrimination. And what we've said in our printed case, but I won't take up the time on, is when you look at the explanations for this provision, the explanations make no suggestion that Article 21.1 is radically wider in this respect than Article 21.2. The difference is Article 21.2 is only concerned with nationality discrimination, and Article 21.1 is concerned with not nationality discrimination, but all manner of other forms of discrimination. But it doesn't say in the explanations, well, even though 21.2 is only available in respect of situations within the scope of EU law, 21.1 is a lot wider. And in fact, that would be a remarkable outcome. Because if we turn back to the beginning of this clip, to the recitals to the Charter, the preamble,
yeah.
it says, I'm actually just trying to find the bit that I actually want. Yes, in the fifth paragraph of the recital, this Charter reaffirms, with due regard for the powers and tasks of the community, the principles of subsidiarity, the rights as they result in particular for constitutional traditions and international obligations common to the member states, etc. So it's a reaffirmation of existing rights. It's not a radical extension of those rights. And in the case of anything that corresponds to the European Convention on Human Rights, it says that they shall have the same meaning and effect, but obviously insofar as possible within the scope of EU law. It doesn't bring within the scope of EU law a whole raft of situations which would otherwise be outside.
Yeah.
So with all that in mind, I now want to tackle briefly, and by reference to one authority, the alternative way Mr. Saini puts this part of his case, which is the alternative comparator based on Surinder Singh. And this is the hypothesis that the French wife, Mr. Nouazli in fact had a French wife, and she is worse off as compared to a British wife, had he married a British woman. But our high-level submission on this is that this comparator is wholly hypothetical, because we know that Mr. Nouazli's wife was unfortunately separated from him in 2005 and went back to France. She's not before the court, and there is nothing at all to suggest she is in the slightest bit interested or concerned about his 9 weeks of detention in 2012. The foundation of this claim is his rights derived ultimately from the Citizenship Directive. Now he has those rights in the first place because he was married to a French worker.
Is it open to him to say that the article or the regulation is nonetheless unlawful because it would apply in such a case, and therefore it would be unlawful, therefore it fails?
No, my lord, no. I absolutely accept that forgive me for using slightly disrespectful shorthand, but if a French wife if the act complained of really did give rise to a detriment on the part of a quote-unquote French wife, then there could be a claim. And I don't make a standing point here as though only she could bring the claim, her husband could never bring the claim. I don't say that at all.
I understand you say it's entirely theoretical to this case, hypothetical, I understand that. But all I'm saying is if you can show that inevitably it will have that effect, as a matter of automatically have an unlawful effect on a certain hypothetical facts which are not fanciful.
Well, with respect, my lord, I don't think one can say that. Right. It would be fact sensitive because bear in mind what we are talking about here is detention prior to removal. We're not talking about even removal itself.
I know.
So fact sensitive question, but I do want to deal briefly.
Let's rise in this way. If you're thinking about free movement of EU members, has to run something like this, that Madame X may be deterred from bringing her extremely valuable skills to the UK because she has a reprobate husband and she thinks it's quite likely he'll carry on offending in the way he has in the past, and it's not impossible that he may then find himself detained while they're deciding whether to deport him. That might enter into her calculations in deciding whether to bring her skills here, and is therefore the regulations unlawful.
Well, my lord, we would say in answer to that claim that if the matter she's complaining of is her husband would ultimately fall foul of Articles 27 and 28 of the directive, then that's precisely what the legislation provides for. So there's no argument to say because my husband may end up being a person who is subject to action because his removal would be because his presence gives rise to a genuine and present threat to matters of the public interest, I'd rather not come to the UK. That's precisely the kind of restriction on free movement that the directive allows. Now, there's a separate question, which is the final part of Mr. Saini's case about implementation and about the fact that there's only a reasonable grounds threshold. But I will deal with that. Evidently, it will be tomorrow. But in my submission, I don't say there could never be a so-called French wife claim. I say this is not one, and that the court in this case is not in a position to grant the relief that Mr. Saini seeks, which is that this provision should essentially be invalidated because of this possibility. And I want to show you...
Is there any EU law proposition, authority along the lines that when you are looking at questions of comparison and discrimination, you're entitled to have some regard to substance and reality? In other words, imagining some highly hypothetical and improbable case in which there would be arguably a breach is not enough to make a measure unlawful.
Well, look, can I give an indirect answer to that, which is to say, in our printed case, we set out a lot of authority for the proposition that if there is invalidity in EU law, what one does is set aside on a case-by-case basis. And you will have seen the authority, ICI and Colmer is one of my friend's authorities. We quoted Incogi and a couple of other cases. So the correct position is, if someone comes in front of the court and says, my directly effective EU law rights are being infringed here, then the national measure can be set aside so that their rights can be vindicated. But it doesn't follow, just because there is such a one person, that the entire measure is invalidated, just as in Ali and Bibi decided last week. So I was just very...
Where do we find that in your case? Because I don't want to hold you up now. But
my lord, I'll just turn it up.
Look,
It's towards the end.
Right, look, mention it later. It's all right.
My friend will find it.
I don't want to interrupt you unnecessarily.
I was simply going to show Surinder Singh because that's the authority that Mr. Saini says, in fact, supports the proposition against me. It is in the supplementary bundle of authorities, volume 15.
Yes.
And this is said to be authority for the proposition that one can take that there's a detriment to the spouse that is relevant here, despite divorce. But Mr. Saini did deal with this very briefly, but didn't really accurately characterise the facts of it. So I do need to show the court very briefly what it says. I'm sorry, I haven't got the tab number, if you just bear with me a moment.
180.
I'm very grateful, 180. And we can just need to look at the facts very briefly on page 98.
And an electronic number?
I'm so sorry, it's page 98.
Is this in the supplementary?
This is A15, the Appellant supplementary bundle, and it's sup MS page number 98.
Thank you.
Just in answer to the question about where in my case is the discussion of, no, that's the appellant's case. I want our bit, sorry. So I'll stick with Surinder Singh for a moment. Fine. What Surinder Singh is authority for is the proposition that there can be if a UK national leaves the UK to exercise their free movement rights under EU law, that also implies a right to return. And the right will apply to a third country national spouse. Obviously, that's got nothing whatsoever to do with our case, but I'll show you why this does not help Mr. Saini. So on page 98, the facts are very simple. It appears, paragraph 3, it appears from the order of the National Court that Surinder Singh married Rashpal Purawal, a British national, in 1982, but from 1983 until 1985, Mr. and Mrs. Singh were employed in the Federal Republic of Germany. At the end of 1985, they returned in order to open a business.
Yeah.
Now, I think Mr. Saini said, I'm sure by accident, that they were divorced by the time they returned. And that's what I heard him say, but it's not right, as we will see.
That we see from the next paragraph.
Yes, exactly. In 1986, Mr. Singh was granted limited leave to remain in the United Kingdom as the husband of a British national. In 1987, they became divorced. And then the British authorities cut short his leave. Then he was served with a deportation order. And then the court he challenged this under EU law, and the court referred a question at paragraph 9. Where a married woman who is a national of a member state has exercised treaty rights in another member state by working there and enters and remains in the member state of which she is a national for the purpose of running a business with her husband, do Article 52 of the treaty, which is free movement of workers, and a council directive entitle her spouse to enter and remain in that member state with his wife. In other words, is he free to go with her and come back? And the answer they gave was yes. But one thing I just want to draw attention to, Directive 73148 is one of the precursors to the Citizenship Directive we're concerned with. It's one of many measures that was repealed and consolidated into it. We put it in our supplementary clip handed up this morning. And the important thing is, like the present directive, it gives the spouse a personal right. And the answer the court gives is there is a right to return. And it says essentially because there would otherwise be a deterrent effect from going in the first place. So a British national goes to Germany with their spouse, they need to be sure their spouse can come back. And as a result, Mr. Singh continued to enjoy his personal right to reside in the UK, which, just like Mr. Nouazli, persisted after his divorce. And you can read that. I won't take you through it, but it's between paragraphs 19 and 21.
Thank you.
But what this does not say is that Mr. Singh could sue in, I actually don't know the year, 1992, because of some hypothetical effect on his wife in 1992. It said he had a right derived from her exercise of free movement, which had happened in 1983 whilst they were still married. And just like Mr. Nouazli, that right had persisted.
So you say what they held was application of this brackets assumedly valid rule, close brackets rule, on the facts of that case would have been an infringement.
My lord, I'm sorry, I didn't actually catch the beginning of the question.
On the application of the valid rule, it would have been an infringement.
Application of which rule?
Of debarring him from
Yes, it would have,
back.
but it would have interfered with the right that he had,
No.
albeit that his right had originally derived from her exercise of free movement.
Yes.
My lord, I was going to just give the reference to where we say in EU law you take a case-by-case process to annulment as
Yes.
opposed to
Paragraph.
It's in our printed case on MS pages 187 through to 189.
Thank you. Right, thank you. Yes, I remember. Thank you very much. Yep.
So I have another 10 minutes, and I want to just really get, having done an enormously long preamble, to what we say this says about our case on discrimination. you will have, obviously the effect of all I have been saying is that this does not involve any form of legitimate comparison, and that it is wrong in principle for the appellant to say, here is one isolated provision which makes me worse off, because that provision itself is a creature of the regime that flows from EU law rights and that shapes the provisions that can apply to people exercising EU law rights in a way that does not apply to those who are not. Now, Mr. Saini called this a net accounting approach, and we would respectfully submit we are very far away from that indeed, and we're very far from Lady Hale's example about giving up seats on a tube. These are heavily interlinked provisions. The power that we are here to consider itself reflects the particular characteristics of the EEA regime, the high threshold test before any removal action can be taken, and the lack of certain control mechanisms which are available in the non-EEA context. So what we have is different means for achieving the same objective. And those differences are themselves shaped by the differences in the EU and non-EU regime. And what Mr. Saini sought to meet that with were some cases on equal pay. And of course, as he rightly says, the Barber case says, when one looks at equal pay, one can't aggregate all of the elements. But the reason for that is obvious and indeed expressed in the judgment. Otherwise, the system becomes too opaque to be workable. So what the Court of Justice said in, I'll just give the reference but not go to it, Barber, which is A15 tab 181, at page 169, paragraph 34, the concern of the Court of Justice is the complexity of the components of pay may make it difficult to ensure effective review. It's a transparency problem in equal pay. And then the other case he mentioned, Roma, which is about a comparison between a retirement pension payable to married couples versus someone in a registered life partnership. What the Court of Justice said is focus on the benefit rather than an overall comparison of marriage and life partnership. And we have no difficulty with that proposition. But here we are dealing with something rather different. We're not just saying, look at all of the lovely things that EU law gives you. We're specifically looking at their regime for exercise of rights of free movement and removal. So in our submission, that really is the end of the case on discrimination, whether it's put in terms of common law, human rights law, or EU law. There's no difference for any difference. Certainly, there's no reason to suppose the common law gives a different reason. Just like EU law, common law ought to recognise, firstly, the appellant is better off, and secondly, that his differences do flow from these systems of rights. Why does that offend the principle in Matadine and Pointhieu? In our respectful submission, it's perfectly rational. Now, if you're against me on absolutely everything I've said, I can try again and formulate essentially the same points as a matter of objective justification. I said at the beginning that one can essentially cut the cake in different ways in this case. But what we say about that is that the policy object of this rule is apparent, which is to ensure that the decision to remove an EEA national is not circumvented so as to protect the public during the completion of its decision-making and to ensure that removal is effective. And that you can find that expressed in our case in those terms in paragraph 155. And if you step back from that, the higher level of objective is to seek to ensure the United Kingdom is free from foreign nationals whose presence is undesirable. Both regimes, EEA and non-EEA, contain a number of powers to serve those aims. This particular power of detention allows the Secretary of State to properly consider whether the requirements of the directive are satisfied without the risk of harm to the public eventuating or the subject absconding. If there is a difference of treatment here that needs to be justified, then the justification arises because the Secretary of State has a whole set of different tools available in the non-EU context. And now I'm simply at risk of repeating what I've already said. The tighter, broader controls, administrative detention with accompanying administrative removal with power of detention, automatic deportation and power of detention.
But of course, if you have to justify something, what you have to justify is the difference.
Yes.
So you would have to say, wouldn't you, that this whole scheme of EU law rights makes removal substantively a great deal more difficult than it is in all the others.
With the greatest respect, that is not what I'm saying.
Well, I'm putting to you that possibly you should be saying this.
Well, I don't go that far.
Well, the reason that I'm putting it to you, because you have to justify the difference. Now, you've made the point that there aren't that many differences and similar powers do actually arise elsewhere, which is a different point. But insofar as there is a power to detain before the decision has been taken to get rid of this person, you have to say, well, why is that necessary when it's not necessary in other contexts or in all other contexts? To which you might say, this is because the power of removal requires the Home Secretary to go through so many more hoops, so much tougher. The criteria are tougher. You've got to look at proportionality. You've got to look at all the stuff you've got to look at in Articles 27 and 28, and therefore she needs more time, and this is likely to be an even more undesirable person than the other people that are being removed under other powers, and therefore it's all the more important that this person should be under close control why that's going on.
Yes.
You're getting some nods from behind. I'm getting some nods from behind you.
I don't dissent from that broad proposition. Subject to, I want to be clear, though, that there are some caveats to it. And as we said in our printed case, we are not saying that this removal is harder in all cases. And of course, I've also said there is, in fact, a very, very similar power in respect of administrative detention for breach of conditions. So it would be incoherent for me to be saying, oh, well, this is only a problem in the EU regime. But as the nods that I couldn't see but your ladyship did suggest, that of course this is a high threshold. Of course there is a specific rubric. And of course we are dealing with people who are at this high threshold where this concern is a very serious one. But I do say, though, that irrespective of that, the objective justification is this is obviously a necessary power to have. Whether it's necessary to use in an individual case is a case-by-case matter, and the very same problem is dealt with by different means that are not available in the EU context. So
is it right that it didn't? When did it first exist in the EU context? This necessary power.
It was 2009 it was introduced.
So
and one of the things...
It wasn't necessary before.
Well, there was a policy judgment to introduce it, evidently. And what we say about that, and that, obviously we know that as part of Mr. Saini's case, is that when one looks at what has happened since the year 2000, which is the benchmark for this purpose, there has been a toughening up of the regimes, both EU and non-EU. So we've had the introduction of the Borders Act in 2007 with its automatic deportation, and I gave the court a flavour only of the way the rules have become tougher and tougher. Yeah. So there's absolutely no doubt that there is a policy judgment that lies behind all of that, that tougher measures should be taken to keep the UK free of undesirable persons. That's plain in both the EU and the non-EU regime. I can't offer a specific explanation of why it wasn't in there originally. I don't seek to try. But the fact that this all expresses a toughening up is inescapable. And indeed, as Mr. Saini said, when this power was first introduced, it was even a power to detain people who simply lack the right of reside, people who, or reasonable grounds to think they lack right of reside. That went away. It's not an issue in these proceedings. But the broad policy thrust is pretty clear by implication.
Is that a convenient moment?
Yes, for me, yes.
Sorry, was there something you wanted to add?
No. Those I think will conclude my submissions on discrimination, leaving me with the other three topics to deal with tomorrow.
Thank you very much. Well, we'll resume again then at 10:30 tomorrow. Thank you very much. Court's now adjourned.